Remember that next time. Good morning.
Good morning.
May it please the court, I'm Julie Pierce. I represent the appellant Donald Hodge. I would like to reserve 5 minutes for rebuttal. The trial court entered an amended final judgment that contains 5 errors, any one of which we believe necessitate remand. The first was the court ignored the calculations required by the Florida Supreme Court in Ka'a'a versus Ka'a'a. This would be a legal requirement requiring de novo review. The court said in Ka'a'a that passive increases...
Is it really pronounced Ka'a'a?
I'm not sure. I went to Hawaii once. It sounds like Ka'a'a, but there are 3 A's. I'm doing my best.
Let me ask you about, because that's an issue that I find interesting, and I want to ask your opposing counsel about it. This, if I remember this correctly, this is the issue involving the property that's up north.
Yes, sir.
Which your client owned before the marriage.
That is correct.
And that the trial judge concluded that it had appreciated. I know it's not $400,000, but it's, I'm just going to say $400,000.
Actually, it was more than $400,000.
Right. It was in excess of, I think it was $515,000, and it was worth $80,000 at the time of the marriage, and there was a $20,000, $22,000 mortgage.
You have it all correct.
What I'm trying to understand here is, so the trial judge makes the conclusion that the appreciation was not passive, or was not entirely passive, because Mrs. Hodge contributed labor and rental and that sort of thing, which turned the property, the appreciation of the property, into a marital asset, which he then split. Am I right on the facts?
That is what he said, but there was no evidence.
I understand. I'm just trying to make sure I've got the lay of the land. So let me ask you this. You don't disagree that under Ka or Ka'a'a, that if the right facts exist and the judge applies the 5 elements, that making non-marital appreciation marital is possible. You just don't think it applies here.
Yes, you can make appreciation marital,
Right.
But there have to be improvements or enhancements to the property.
Well, or marital efforts, and that's where my question now, we finally get, I guess, to my question, is the trial judge concluded that Mrs. Hodge did some things. She rented the property out. She apparently helped with tenants. She paid the bills that were related to the property, which again, admittedly, apparently are not a whole lot. They went up there one time and put siding on the house, and they did some railroad ties and some other sundry things. Did the trial judge simply say, well, you put some effort into the house, and so I'm going to make the appreciation 50-50? Or should the trial judge, in your mind, say, well, Mrs. Hodge, you did some things that helped the house, but of the $400,000+ appreciation, the majority of that was market-driven and had nothing to do with the efforts of either party. So I'm going to say that your efforts, and I'm just making the numbers up, your efforts maybe help 20% of the appreciation, so I'm going to split 20%, and the remaining 80% would have happened if nobody had done anything. It was just market-driven. Do you think that's what should have happened, or do you think that the trial judge simply concluded that she made no meaningful effort and he shouldn't have awarded anything?
I think that she made meaningful efforts that did not enhance the value of the property, but I would agree with you if the court found that her efforts enhanced the value of the property, the court would then have to find, pursuant to the terms of Ka'a'a, where they specifically said that the court must determine to what extent the contributions of the non-owner spouse affected the appreciation of the property. So I think that the court had to make that specific finding, and after they made that finding, then the court had to apply the formula. But the court skipped all
Your
that.
view, though, is when they talk about appreciation, you don't, under that very strict, fairly narrow view of ka, you think that, for example, her efforts to rent the property, pay the bills, pay the taxes, I assume, that sort of thing, would not fit under the category of appreciation, and so she should have gotten no part of the enhanced value of the property.
Well, I think she should get credit for what the marital estate paid for, the $22,000 mortgage, and the $2,000 some odd siding.
Right.
But I don't think that this court in Leader indicated that repairs are not enhancements. And I would maintain that renting the property out doesn't enhance the property's value. The court below specifically said to me, she saved it from depreciation, but maintenance and keeping the property afloat is not the same thing as improvements. And I think that
The value of the property is tied into how much or how little the property is encumbered, which goes into the value of the property at the time that it's appraised. If you have a piece of property that has a number of liens against it because it's either been mismanaged or there's been a failure to mitigate any damages if there's a pending litigation against that property, that's a value that is more than just putting siding on and putting railroad ties in the ground.
certainly extinguishing any debt associated with the property through marital efforts or through marital funds would be marital.
But you're
there
doing
was-
more than just extinguishing debt. You're actually managing the property and generating income from either a good or a poor management of the asset, which would be the marital property, correct?
Yes, I would have to agree with that, but that just keeps it at the status quo. It doesn't improve the property.
Well, but it doesn't just keep it at the status quo, because obviously you have a market that's either driven up or driven down as far as real estate value, and if you do not have a property that's fully unencumbered during that process, you don't have the benefit of the full value of the property based upon what the market is driving the price at, correct?
If you allow the property to go into disrepair, if you allow the taxes not to be paid, certainly the value of the property would not appreciate. But I think that does not agree with the ruling in Ka'a, where they're talking about enhancements and they're talking about appreciation. And they didn't say anything about regular maintenance of painting or taking care of the lawn or paying the taxes or insurance. The Ka'a court talked about extinguishing the mortgage, and they talked about improvements and enhancements to the property. I don't think that maintaining the status quo on the property is what the court was talking about when they were talking about marital efforts.
Is your argument that the trial court didn't specify what is passive appreciation and what was subject to what the wife did to, and therefore, because he didn't specifically delineate, that we can't know where this figure came from?
Well, I think that it's threefold. The first being that there were no enhancements. He didn't find any enhancements. He said she maintained the property. And then he used the word enhancement because I kept saying that Ka'a requires enhancement. Second, that the court did not delineate the passive, what marital efforts affected the appreciation, which is specifically required in Ka'a. And then when all was said and done, he did exactly what the court did in Wyoming and just gave Mr. Hodge the value of the property at the time of the marriage and didn't apply Ka'a at all. So I think that there are threefold issues that he did not address. The second issue was not accounting for the net value of the rent, the rental value of that property was put in Mr. Hodge's column of $1,650. The court failed, and that was the gross rent. The court failed to net that rent out. That is a misinterpretation of 61.08(2)(I) under Betancourt, and we believe it's subject to de novo review. The $1,650 was completely uncontroverted. Both parties testified that at least half the value was utilized. I did raise the fact in my brief that when you looked at the parties' tax returns, it was actually a whole lot more expenses, and the actual average income was approximately $273, but we're more than willing to live with the $825. That was what was testified to, that taken in light most favorable to the wife. That would be the appropriate number, but that's not what the court did.
The wife indicated her rental income on her financial affidavit was $300 a month.
Right, but when she testified that approximately half the money was set aside. So, yes, there were multiple times where she put a lot less rent down there than $825 as the net value. But the fact is, that's approximately 10% of my client's income overstated, and therefore it makes a significant difference in what is available for alimony. And then the court failed to... Yes,
Before
sir.
we move on to another point, let me just bounce back to the first point.
Yes, sir.
Would it be your position that if a piece of, if this property had been worth $80,000 when they went into the marriage, and Mrs. Hodge went out and mowed the grass every week, paid the bills, paid the taxes, got the tenants, but at the time they got a divorce, let's say it was still only worth $80,000, that those efforts by the non-owner would not entitle her to anything?
That is correct. That is my reading of the case.
And if it went up to $100,000, they hadn't done any improvements to the property. It went up to $100,000 primarily because of just market forces. That her efforts to manage the property and cut the grass every week for whatever number of years and that sort of thing would also not allow her to get any portion of that property.
Yes, Your Honor.
So your view is only, for example, if they went out and, put on a new roof, made an addition to the house, did something along those lines, those sort of improvements, would that then allow her any portion of the appreciation?
That is correct.
Okay.
With regard to the investment income, the court moved over $400,000 in the end analysis. $400,000 will be moving from what is currently in Dr. Hodge's name to Mrs. Hodge. The court attributed no income value to those monies. The court did not award her a number. The court awarded her half of these assets, and the court made specific findings as to the income associated with those assets. Appellee argues that we didn't prove what those assets would make, but the court specifically found what those assets would generate, and there's no reason why they wouldn't generate the same amount in Mrs. Hodge's hands as they would in Mr. Hodge's hands, because they're moving over the asset, not the money. And so we believe that Mrs. Hodge's income is understated by $1,693.76. But more importantly, certainly, nobody can argue that Mr. Hodge continues to have that money. When you move a third of the money away from him, that money is not available from which to pay alimony. And we would submit that this is, again, a failure to properly interpret 61.082I and is subject to de novo review. The Supreme Court in Acker versus Acker made very clear that the court is to do equitable distribution first and then establish the alimony, if any, and the court simply didn't do that. The court delineated Dr. Hodge's income and then said that there has to be an equalizing payment, but made no calculation that associated with how much income that could produce or what it would do to Dr. Hodge's income. Next, we have the alimony issue. Mrs. Hodge testified that she needed $2,000 a month. The court awarded her $2,500 per month. This court in Nolan versus Nolan indicated that where a wife was asked for $988 a month, and the court awarded her $1,500 a month without giving any reason for the discrepancy, that the court had to be reversed because...
But didn't you have a first mortgage on the common marital home, that it appears that the judge took that into consideration? She said $2,000, and she was not citing the responsibility of the first mortgage. You had the husband who eliminated or paid off or satisfied the 2 educational loans on the property, but she was still responsible for the mortgage, correct?
No, he paid off all 3 mortgages, and that is, he was specifically authorized to do so during the court's rulings, and we supplemented the record with the oral ruling on that issue because the judge specifically indicated he could pay off those mortgages so long as he provided the tax information for Mrs. Hodge so that she could then deduct get the tax benefit associated with paying off those mortgages. But he paid off all 3 pursuant to authorization by the trial court. And then when we went back to rehearing, both the trial court and opposing counsel recognized that he had paid off all 3 mortgages, and so she no longer had that requirement. And so the justification, if any, for going above what she had requested would no longer exist by the time of the final, the rehearing.
You've got just over 2 minutes left if you want to hold on to that for rebuttal.
Yes, sir.
Ms. Harris, if you'd like to speak from there, you're welcome to it.
It's okay. I'll be more comfortable there if you just...
Okay.
give me a-
Take your time. If your colleague wants to help you get up there, that's fine.
I've been on these a while. I'm getting pretty handy with them. Good morning. My name's Elizabeth Harris, and I'm here on behalf of Mrs. Hodge. And I thought you pronounced it Kai, so I'm going to pronounce it Kai if that's okay. I'll start there as well. And the significant obstacle that I think Dr. Hodge has here is that the judge made the specific finding that Mrs. Hodge's efforts were a direct result of the improvement in the property. That finding's not being challenged before this court. They've not come forward with the argument on appeal that there was insufficient evidence to support that finding. That finding stands here. So I would suggest that that completely takes it out of the Kai scenario. Because in Kai, the court says, based on the circumstances of this case, and when we look at the circumstances of that case, factually it's very different than the situation we have here today. That's a situation where they lived in the premarital home, there was not much done to the house, and they just lived in it. Mortgage was paid off over the course of it. What we have here, and I would agree with you, Judge Wallace, is that this is an income-earning asset. Family doesn't live in any longer. It completely changes the scenario. So we have 2 problems. We have the judge's finding that's not being challenged here before the court, and so that finding must stand here. And we have facts that are vastly different than what's in Chi. And they limit it to the circumstances before them, in that Chi case. And they say, we'll apply the Stevens methodology under these facts. I would suggest that when you have an income-earning asset that is, as Dr. Hodge testified, yielding a positive cash flow yearly on their income tax return, we're out of the specific circumstances of Chi. Now, on to the other issues, starting first back as Mrs. Pierce did. I would suggest that with regard to taking out the $1,600, $1,650 of the rental income, at the time of the rehearing, Dr. Hodge concedes that his income is approximately $9,000. That's the figure the judge uses in the final judgment. When the judge lists the different assets, he says going forward, he's going to have approximately $9,000. That's the figure, even in the reply brief, that Dr. Hodge is asserting. So I think they failed to demonstrate any error here. They're agreeing it's $9,000. That's the figure the judge uses.
Let me ask you to back up, because I wanted to go back, looking at the judgment on what the judge called the Old Dominion property.
The Old Dominion, is that what you
Right.
said, sir?
Yeah. And what the judge says was that the property was purchased by husband before the marriage, had an $80,000 mortgage, current value of $515. The parties resided there, and then it became a rental. And so this is what he says. The court finds that petitioner wife is entitled to 1/2 of the increase in the value of the property during the marriage, or $515 minus 80 divided by 2. Where in the judgment does the court say anything about, and maybe I just missed it, about her efforts and all that stuff?
It's in rehearing at the, I'll give you the record citation, sir. It's at R625 through 626. It's I believe it's during the motion for rehearing, but my brief indicates 625, 626. He says, I divided in half. The reason I divided it in half was the passive appreciation of the property, as well as the very active participation of the wife in maintaining and utilizing the property as a money-making asset, that it became a rental property. I'll go on further and find that direct.
But he makes no specific finding of this is what, this amount I find of the appreciation, that this amount is passive and this amount is due to wife's efforts. He never does that, does he?
No, he doesn't do any type of division, but I would respond that I don't think he has to do that.
Well, doesn't COD say he has to do that?
Well, but I would say that if we had the circumstances set forth in Chi, we might have that problem, but we don't. And they tell us, based on the circumstances of this case, we're going to apply the Stevens methodology, because that formula derives from the Stevens case out of the 2nd District. What we have here is facts that are very different, and a finding that's being unchallenged in this court that her efforts are what increase the value. So we don't have a Chi case.
But he doesn't say her efforts increase the value from $80,000 to $515,000. He never says that. I mean, I haven't heard him say that. I guess we can assume
I'm not sure. Can I ask you to ask that question again, because I'm not sure I followed you.
The judge never says that the wife's efforts increase the value from $80,000 to $515,000.
He doesn't, I'm sorry to overspeak you, he doesn't say it was the sole reason, if that's what your question is.
I think that comes back to my question is it an all or nothing? So let's look at this property and just hypothetically, let's say that the appreciation was $400,000. I know it was a little bit more. the appreciation from the 80 that Dr. Hodge had to the 515, it's really more than 400, but, you know, in excess of 400. If she had gone there once a year and changed a light bulb, that would be an effort that helped maintain, I guess, the value of the property. If she squirted WD-40 on a squeaky door hinge, that would help maintain the property. If the judge said, well, you participated in the maintenance of the property, does that then create a situation where she's entitled to 50%? Or could the judge say, for example, well, yes, you did some things. I think that 80% of the appreciation was simply market-driven and would have happened if you had done nothing, but that your efforts to oil the hinges and change the light bulbs and, you know, paint the front porch helped a little bit, and so I'm going to say that that was 20% of the appreciation. Is that the right way to do it, or does it come down to an all or nothing, where the judge says, well, you did some things, and there's no question Mrs. Hodge did things that helped preserve and probably cause the property to appreciate. I don't know what that percentage ought to be, but is it within the judge's discretion to say, well, I find that that was maybe 20% of the appreciation, or 10 or 30, whatever the judge comes up with? Or if the judge, or is it your view that if the judge makes a finding that her efforts contributed in any way, regardless of how large or small, that it becomes a 50-50 proposition?
I think the issue I would have with your question is it overlooks that this is not the home they're living in, but it's an income-producing asset. And I think that changes the scenario. It pulls it outside of CHI where, in those situations, the married couple was living in the home. Here we have an asset that they're not living in, that's bringing money into their household. And she is the manager of that. That has to be a significant factual difference. It removes it out of the CHI case.
I absolutely agree that she made efforts that, at the least, maintain the property and more likely help that property appreciate. What I don't know is whether those efforts turn that non-marital appreciation into 50% marital, which the judge did, but we don't know why. And I'm just trying to understand in whether it's rental property or not. You know, if she's really active, and as using the example I had before, she's mowing the grass every week, she's painting the building every couple of years, she's finding the tenants, paying the bills, you know, patching the roof, all that sort of thing. That scenario might lead me to conclude that 50%, her non-marital efforts really were that significant. At the other end of the spectrum, you know, I use the example if she changes 2 light bulbs and paints the porch once in 30 years, does that latter scenario entitle her to 50% because the judge finds that her efforts did improve the value somewhat, you know, keeping the property in good repair helps it go up? I'm just trying to understand if the judge ought to, if he makes the finding that her marital efforts contributed, if it automatically becomes 50-50, or if the judge should then say, all right, it appreciated 400, I'm going to say that the marital efforts caused X percentage of that increase, and passive market-driven forces caused Y percentage. Because the judge here did the former. He just said, I find that her efforts contributed, so it's 50-50.
Right.
And I'm just trying to understand whether that's the right way to do it, or whether the judge ought to then go to that second step and say, so much of it would have happened no matter what, but X percentage was because of the efforts of the non-owner's spouse.
I think at where the judge stood at this point, that it was he's finding it, he doesn't say these words, but I think he's found this case to be outside of the CHI decision. I think he then was within his discretion, and he certainly didn't have Dr. Hodge suggesting he needed to do anything different.
Well, let me ask you this. If it is within the CA decision, are the findings insufficient? Is what the judge put in the final judgment with regard to the Old Dominion property, that calculation insufficient? If CA controls.
If Kai controls, if the decision in Kai would include facts outside of Kai,
If it controls,
then, then the methodology is what the Stevens Court says, and they specifically say is appropriate. When you have appreciation that occurs, that is passive, I think, and you have the facts that are set out in Kai, then I think the court would have been bound by Kai.
so the answer is it is insufficient if we have to follow CA.
If you find Kai applies, yes.
In your view of...
I think that the methodology set forth is pretty straightforward.
And tell me again why you think that methodology, the CA methodology, does not apply?
I think there are
Because this is rental property?
at least two reasons why Kai doesn't apply here. One, because the court makes a specific finding that her very active and direct efforts is what caused this property to go up.
But that would be consistent...
But that finding's unchallenged here.
But that would be consistent with CA. I mean, that isn't
I
it...
don't think so. I don't think it is. I think Kai seems to say when you have simple passive appreciation, what we have here is something other than that. We have the efforts of the wife who have caused this property to go up in value.
I thought, though, your analysis and why CA does not apply is because in CA, you were talking about a marital home. They lived in the marital home. And here, this is not, your position is it's not the marital home, that it's purely an investment.
Absolutely. That's my second reason why I think Kai doesn't apply, is that this is an income-producing asset. This isn't their marital home. They weren't just residing in this house.
Why does that make a difference? I mean, when I look at the formula of CA, I admit that the CA was a residential property that they lived in. But when you look at the formula that they craft, I don't understand where you conclude that rental property, investment property gets pulled out.
Because I think what confuses the issue here is that it's a piece of property. But if it was a business, and she was the source for why the income was coming out, or being generated by the business, we wouldn't be looking at Kai. We're looking at it only because it involves a house. And I think that's where the confusion lies. It was a home in Kai, and we have a home here, but the home's not being lived in. It's producing income to the household.
No, but I think CA is equally applicable if it was just a piece of vacant property. And the property went up during the marriage, and it may have been because of the efforts of the other spouse to do things. I mean, one of the provisions of CA, and I'm looking at the formula, it says the trial court must determine to what extent the contributions of the non-owner spouse affected the appreciation of the property. And that's really what I'm trying to say, is that the judge should say to what extent her contributions affected the appreciation of the property. And he doesn't ever implicitly he makes that finding by just saying it's 50-50. But explicitly, he never breaks out the difference between passive appreciation that was purely driven by market forces versus what her efforts were. And whatever her efforts were that contributed to the increase in value, I agree with you that CA would then treat that as an asset for equitable distribution. But it seems to me that CA says to me anyway that the judge has to go just a bit further and say either it did contribute to the entire amount of appreciation, which her efforts did contribute to the entire amount of appreciation, in which case they split it 50-50, or her efforts contributed to X percentage of the appreciation, and we're going to split that, and he gets the other part. I mean,
Well, I would agree with you that they do set forth, I think it's 5 findings, if I remember right. There's 5 that they need, that the judge should find, and one specifically looks at what their contribution may have been. I would say that there's an absence of direction further by the court there. What if that they need, the trial judge would have to assign some proportion, some mathematical figure to that contribution. I think the judge here did find that, and I would take your indication that it was some implicit finding, and go further with it. You have to take that he found it was at least 50% responsible for it. And if I could go back to your suggestion that if it was an empty piece of property, that would be a far different scenario than a house that can only be rented if it's maintained. If the...
well, I don't know, people rent just about anything, but...
Well,
So if it was an
that
empty
would be
piece of
true.
property and all Mrs. Hodge had done was pay the tax bill once a year, would it be your contention that that was a sufficient contribution to the property's appreciation that would entitle her to 50% of the property? And that the
I guess I
test
would
in
answer with a
CA would
question
not
in-
apply?
I would answer with a question in return, if that's okay. Is it not significant that there was more to that asset was yielding $1,650 a month into their household?
But I'm asking a hypothetical, which doesn't apply to this case. If it was an empty piece of property, and her contribution was paying the tax bill once a year, and making sure there was insurance on the property, so that she certainly had some effort, and the property increased to $400,000, would that minimal effort entitle her to half of the appreciation?
I think you would have a situation like Kai, that you would be required to follow the formula set forth there.
So your view, the reason that COD doesn't apply here is because this was rental property that was generating a positive cash flow.
I think in part. I think there's also a significant obstacle that finding before this court, that it's a result of her efforts, is unchallenged. So you're faced with the judge having made that factual determination, and that alone has to take you outside of Kai, where in that case, the spouse seeking the appreciation of the home, there's no finding of any contribution on her part to the increase in the value of the home. I only have 20 seconds left, so if anyone has any other questions.
We appreciate your argument.
Thank you.
Thank you so much.
First of all, counsel indicated we never argued about the finding associated with increasing the value of the property. We argued loudly at rehearing and in our brief that the maintenance of property does not increase the value of the property, and and talked about the fact that the trial court argued that avoiding depreciation is increasing the value of the property. So we did argue that issue below and here. My reading of CA wouldn't treat this any different if it was a going business. If the parties worked the business, but the business didn't increase in value and it was a premarital business, that does not change the nature of the business from being marital to premarital. So if she'd worked at a diner every day, I don't think that the nature of the asset being premarital changes. It's whether the value of the property goes up because of those efforts. And the home in Virginia, the Old Dominion property, didn't increase because of the wife's efforts. It increased because of market forces, and she maintained the property. And further, there was no application of the formula required by CAA. It was just ignored. I don't think this goes outside CAA. With regard, the one other issue that we didn't touch upon was the lump sum alimony award of the marital home. The court made no findings of any special circumstances as is required in Lully and a variety of other cases. I read lots and lots of cases, and all of them were reversed for failure to find some special reason why an award of lump sum alimony should be awarded. The only cases that didn't reverse didn't say why they gave it to her except one, and in that case, the husband was avoiding paying alimony by intentionally suppressing his income. And I think my time's up.
Thank you very much. Thank you, counsel. We appreciate the arguments. We'll take a short recess and